POSCO 4 and 5.
Get hold of the other side.
I have informed and he has given me consent adjudication.
If it is not taken up, then it will be taken up at 12:30. If it is not taken up before 12:30, it will be taken up at 12:30. Right?
From mention a case number which is not listed today. From supplementary list for orders. Item 2, Criminal Region 932 of 2023. Case number 23.
Criminal Revision number 932 of 2023. The matter has been listed at the instance of the office. आपने slip file किया था?
Yes.
At the instance of the petitioner, the learned counsel.
We withdrew it.
Okay. At the instance of the office, by stating that the case number has been wrongly typed in order dated 13/6/2024. Peruse the record. The case number, which has been typed as Criminal Revision number 932 of 2022 in order dated 13/6/2024, is directed to be read as is directed to be read as Criminal Revision number 932 of 2023. The order dated 13/6/24 is accordingly modified. Office is directed to carry out the necessary correction. A copy of this order we also sent to the concerned court through fax.
Item 3, Criminal Region 960 of 2023.
In this case, I have challenged this party order passed under section 127 of the CRPC, my lord, where under the compensation has been enhanced from 2,000 to 10,000, my lord. In this regard, my lord, I want to refer page 51. That is the order sheet dated 7/1/2022, my lord. Where under it is mentioned that the case was filed off, which the petitioner is present, heard the petitioner on point of admission. Case is in order and hence admitted. The petitioner is directed to requisite within a week for a appearance of respondent through registered post and Nazarat. Put up the case 162. Thereafter, my lord, without service obtaining service report from Nazarat and only on basis of the tracking report, the order dated 21st/4/2022, the valid service has been confirmed by the Jharkhand Court Bureau and ex parte proceeding was initiated.
Track report is sufficient service of notice.
My lord, in this case, what from
Track
Nazarat.
report is sufficient service of notice.
But what is, in this, what is the matter, madam? The petitioner has filed only tracking report and receipt, not acknowledgement. So
May not be. We accept track report as valid service.
But my lord, it is one of the point, my lord. And in a, and on ground of merit, my lord, the one certificate issued by the
Counsel for the state, you come to page number 52. 52. The case was filed before the Principal Judge Family Court Dhanbad, right? Then it was transferred to another court, Additional PTJ Family Court 2, right? Prior to service of notice. Correct?
52 पेज नंबर
भैया आप उनको पेज नंबर करके नहीं देते हैं क्या? This record was transferred to another court prior to service of notice. उसके बाद service of notice file हुआ. There can be some gap. इनका ये तो track report वाला कहानी हम नहीं सुनेंगे. but there can be some gap.
इसमें लॉर्डशिप रेस्पॉन्ड नंबर 2 बना इसमें इशू नोटिस होना चाहिए।
हाँ, नोटिस ही करेंगे, नोटिस
Notice.
करने के पहले भी बिना सुन के तो नहीं करेंगे। ये आपका नहीं है, this submission is not acceptable.
I know.
That track report, we accept track report every day.
It is one of my submission, my.
पेज 54 में
No, we
lordship,
are not, that we will reject outright. There
पेज
is-
54
But-
में 25
My lord, I am.
service
I
is
am
valid
not.
and transports and track report shows item will be confirmed on etc.
That's right. But this notice was issued when the matter was pending before the previous court. उसके बाद court transfer हो गया. So there can be some gap, right? यही submission आपका लिख के कर देते हैं. That is better.
CT.
Criminal Revision number 960 of 2023. Counsel for the petitioner and state is present. Counsel for the petitioner submits that by the impugned order, the petition filed under section 127 CRPC seeking enhancement of maintenance from rupees 2,000 to 10,000 per month has been allowed. He submits that the order is an ex parte order. By referring to the order sheet of the concerned court, the learned counsel has submitted that the notices were issued.
Lordship may be permitted to leave this court.
Yes. The notices were issued and awaiting service report. The case was the next date was on 18 to 2022, and by order dated 14 to 2022, the case record was transferred to another court. The learned counsel submits that ultimately the petitioner did not appear, which resulted in ex parte order. Thus, issue notice to the opposite party number 2 under speed post as well as ordinary process, for which requisites we filed by Friday. Post this case on of July under the heading for final disposal, office to track speed post delivery and prepare appropriate office note with regard to service of notice.
Item 4, Emergent
एक चीज और।
1637 of 2023.
Records की जरूरत तो नहीं पड़ेगी इसमें. Sorry?
The President Revision amendment from confusion case.
Records may not be required.
There is requirement. Your Lordship.
Why?
As because
Why
the-
do you need the record? For
as
what
because-
purpose?
As because the exhibit made by the opposite.
No,
party-
we are not on the merits.
Your Lordship.
It's an ex parte order. It will, at best, it will be remanded. We will not decide the case on merits.
Your Lordship.
क्या हुआ सर? Records की जरूरत है कि नहीं है बताइए, अभी ऑर्डर ही में लिखाएंगे. Let the records be called from the concerned court. Final disposal में डाल दीजिए. उस दिन टाइम मत मांगिए.
No, no, no.
Yes. After hearing the learned counsel for the parties on the point of maintainability of the present case, this court finds that the argument of the petitioner to submit, argument of the petitioner that the impugned order refusing to discharge the petitioner is an interlocutory order, and therefore the appeal under section 14 capital A of the SC/ST Act is not maintainable is primarily based on the judgment passed by the Honorable Supreme Court in the case of V.C. Shukla versus State through CBI, reported in 1980, Supplementary SSC 92. And also the judgment passed by this court in the case of Tinku Prasad Saha versus Suman Saha in first appeal number 18 of 2021. It is further case of the petitioner that the judgment passed by the Honorable Supreme Court in the case of Madhu Lime Sutra would not apply to the present case on account of non-obstantive clause with regard to applicability of the provisions of Criminal Procedure Code as mentioned in section 14 capital A within bracket 1 of SC/ST Act. The petitioner has submitted that section 11 of the Special Court Act, which was involved in the case of V.C. Shukla Sutra, is pari-materia with section 14 capital A of the SC/ST Act. It is his further case that the judgment passed in the case of Madhu Lime Sutra has been considered in the case of V.C. Shukla, and on account of non-obstantive clause, it has been held that the wide import as while interpreting section 397 within bracket 2 of the CRPC would not apply as in view of the non-obstantive clause in section 11 of the Special Courts Act, which was subject matter of consideration in the case of V.C. Shukla, and correspondingly the same would not apply in the present case, and accordingly the impugned order is not appealable. यही है इनका case total, correct?
Yes.
It is their further case that in a case where the petition for discharge is allowed, the proceeding terminates, and in such circumstances the appeal would lie. But if it is not allowed, as in the present case, then the appeal would not lie and the present revision should be entertained. Meaning thereby, the impugned order would be an interlocutory order under section 14 capital A within bracket 1 of the SC/ST Act, but the present revision would lie as the same is to be treated as then how this revision also will lie, right? So, but the same would, but the present revision would lie. अगर इंटरलोक्यूटरी है तो ना तो वो लाई करेगा ना ये लाई करेगा, कुछ भी इतना टाइम वेस्ट करता है. मीनिंग देयर बाई नहीं, बस इतना ही लिखिए. In order to appreciate the aforesaid submissions of the learned counsel for the petitioner, section 397 of CRPC is quoted as under. The Honorable Supreme Court, in the case of Madhu Lime Supra, considered the earlier judgments passed in the case of S. Kuppaswamy Rao reported in versus the King reported in 1947 FCR 180 semicolon Amarnath versus State of Haryana reported in bracket 1977 4 SCC 137 and held in para 13, 14 and 15, 12 to 15. Held in paragraph 15 as follows. The Honorable Supreme Court in the same case clearly held that the it was not the intention of the legislature when it retained the revisional power of the High Court that only those orders would be revisable which are passed on the final determination of the action but which are not appealable under the Code. The legislature on the other hand had kept intact the revisional power of the High Court and on the other hand put a bar on the exercise of that power in relation to an interlocutory order. It has further been held that the real intention of the legislature was not to equate the expression interlocutory order as invariably being converse to the word final order, and that there may be an order passed during the course of the proceeding which may not be final, but yet it may not be an interlocutory order pure and simple. And by a rule of harmonious construction of subsection 1 and 2 of section 397, it must be held that the bar in subsection 2 is not meant to be attracted to such kind of intermediate order. The Honorable Supreme Court further held that it was neither advisable nor possible to make a catalogue of orders to demonstrate what kind of orders would be interlocutory and which would be final, and then prepare an exhaustive list of those type of cases and orders which would fall between the two. The Learned Counsel, during the course of arguments, does not dispute the fact that under the normal circumstances, that is, in a proceeding arising out of IPC, and if a revision is filed against the order refusing to discharge, the same is maintainable. But what falls for interpretation before this court is as to whether the appeal would lie against the order refusing to discharge. And consequently, the revision is excluded. The provision of in the case of B.C. Shukla, the matter was arising out of order framing charge, and the parties were governed by Section 11 of the Special Courts Act, which is quoted as under. Upon perusal of Section 11 of the Act, this court finds that it starts with non-obstantive clause and clearly provides that notwithstanding anything in the code, an appeal shall lie as a matter of right from any judgment, sentence or order not being interlocutory order of a special court to the directly to the Supreme Court on both fact and law. At the same time, by virtue of subsection 2, it has been clearly provided that no appeal or revision shall lie to any court from any judgment, sentence or order of a special court. Subsection 2 is not further qualified by any term as interlocutory order, meaning thereby that the appeal or revision under section 11 within bracket subsection 2 against any judgment, sentence or order was clearly barred. Correct? This court finds that the Honorable Supreme Court, while interpreting the aforesaid provision of section 11, this court finds that before the Honorable Supreme Court in the case of B.C. Shukla, an appeal was filed against the order framing charge, and an objection was raised that the appeal was not maintainable. And while interpreting the argument was opposed by referring to the judgment passed in the case of Madhu Livi. The Honorable Supreme Court ultimately recorded that the judgment passed in the case of Madhu Livi was rightly decided, but the wide meaning which has been given in the case of Madhu Livi will not apply in view of the specific provision of Section 11 of the Special Courts Act. Upon perusal of the provision of Section 14, capital A, नहीं इसको देखिए Section 14, capital A of the SC/ST Act is quoted as under. This court finds that Section 14, capital A within bracket 1 starts with a non-obstantive clause with respect to CRPC, and it provides that notwithstanding anything contained in the Code of Criminal Procedure 1973, an appeal shall lie from any judgment, sentence or order not being an interlocutory order of a special court or an exclusive special court to the High Court, both on fact and law. And a specific provision has been made with regard to grant or refusing bail under 14A within bracket 2, which provides that notwithstanding anything contained in subsection 3 of Section 378 of Code of CRPC, an appeal shall lie to the High Court against an order of the Special Court or the exclusive Special Court granting or refusing bail. However, under Section 14 capital A of SC/ST Act, there is no corresponding provision as that of Section 11 within bracket 2 of the Special Court Act, which was subject matter of consideration before the Honorable Supreme Court in the case of V.C. Shukla's. Meaning thereby that there is a specific provision of appeal under Section 14 capital A of SC/ST Act against any judgment, sentence or order not being an interlocutory order and also there is a appeal provided under Section 14 capital A within bracket 2 of the SC/ST Act with regard to grant or granting or refusing the bail but there is no specific exclusion of power of revision which may be otherwise available to aggrieved party, inasmuch as there is no similar provision as that of Section 11 within bracket 2 of Special Courts Act, which was subject matter of consideration in V.C. Shukla. If the this court finds that there is a remarkable difference between the nature of provision under section 14 capital A of SC/ST Act and that of section 11 of the Special Courts Act. If the argument of the and accordingly the judgment passed in the case of V.C. Shukla has no applicability, does not apply to the facts of this case. If the argument of the petitioner is accepted, then the order that then if the discharge petition is allowed, the same would be appealable in terms of section 14 capital A, as the proceeding would have ultimately terminated, but the same, if disallowed, the appeal would not lie, and the petitioner is insisting that the present revision would lie under such circumstances. Meaning thereby, the order refusing to discharge will be treated as interlocutory order for the purposes of section 14 capital A, but the same CRPC would not be an interlocutory order for the purposes of section 397 of CRPC. In this court is of the considered view that the aforesaid interpretation sought to be given by the petitioner to the provisions of section 14 capital A of SC/ST Act is not sustainable, and the petitioner would be governed by the interpretation given to such orders as passed by the Honorable Supreme Court in the case of Madhuli. So far as the judgment passed by this court in the case of Tinku Prasad Sahab versus Suman Sah, that is Supra, is concerned, the issue involved in the said case was whether maintenance, pendent delight and litigation cost awarded under section 24 of the Hindu Marriage Act 1955 during the pendency of matrimonial suit would fall in the nature of interlocutory order or intermediate order, and whether an appeal would lie therefrom. This court considered the provisions of Family Court Act Section 19 of the Family Court Act, which is quoted as under Section 19 को quote करना. Under Section 19 of the Family Court also, there is a clear bar under subsection 5 thereof, that except as aforesaid provided under section 19 within bracket 1, within bracket 2 and within bracket 3 of the Family Code 3 and 4 of the Family Court Act, no appeal or division shall lie to any court from any judgment, order or decree of the Family Court. This court also considered the judgment passed in the case of Rajneesh versus Neha, reported in bracket 2021 bracket close to SSC 324. To hold that the objective of granting interim/permanent alimony, to hold that the order on an application for granting interim maintenance does not in any manner crystallizes the right of any party, and it is a temporary arrangement. And was of the view that an application for grant of maintenance being an interlocutory order was not appealable. This court finds that the said judgment has no applicability to the provision of law which is involved in the present case, inasmuch as grant of interim maintenance does not terminate the proceedings pending before the Family Court. VC शुक्ला का पैरा नंबर 34 से ले लेंगे, है ना? 34, 35, 42, 43. You give soft copy of this written submission, right? इसमें से ले लेंगे. ठीक है? So far as the argument of the petitioner, it is also important. Argument of the this court also finds that in the case of VC Shukla, the intention of expeditious disposal of the case was also taken into consideration, and it is not in dispute that the sections 14 capital A was introduced along with other amendments in the SC/ST Act, and one of the main objective was expeditious disposal of the case. This court finds that under section 14 capital A of the SC/ST Act, there are strict timelines to file appeal, and appeal is to be filed within a period of 90 days from the date of the order, and date of the judgment, sentence or order appealed from, and delay beyond a period of 180 days is not condonable. There is also a legislative intent for expeditious disposal of appeal, which provides that the appeal is to be disposed of within a period of 3 months from the date of admission. This court is of the considered view that the appeal prescribed under section 14 capital A serves the purpose of expeditious disposal of the cases under SC/ST Act. And as this court has held that the order refusing to discharge an order in relation to discharge would be an intermitting order as held by the Honorable Supreme Court in the case of Madhu Limin. The present revision is not maintainable, and it is held that the appeal would lie under section 14 capital A within bracket 1 of the SC/ST Act. It is not in dispute that the present revision was filed within the period of limitation. And the matter has remained pending on the point of maintainability of the present case, which has been hotly contested by the parties. Therefore, this court permits the petitioner to convert the present revision into an appeal, and needful be done within a period of 15 days from today. 1 week?
1 week.
Within a period of 1 week today. The office is directed to immediately conduct stamp reporting in connection with the appeal, so is directed to institute the appeal and carry stamp reporting as expeditiously as possible. Yes, yesterday I did not notice one thing, that if they say that it is an intermittent, if it is an interlocutory order for 14, then how the revision also will lie?
That is what we are saying.
That's right. Then revision also would not lie. If it cannot be said to be an interlocutory order for appeal and intermitting order for revision. It is a contradictory argument altogether. Maybe that I did not notice it yesterday. I think I have recorded it in the arguments which has been advanced.
Should put it forward. The only thing is, you must say that they may have a cause, but then do not have the case. But then the point is the harmonious construction. If at all if the construction of a law, the eruption some other conflicts, then the harmonious construction.
And
is the
subsection 2 they had not placed.
Yes.
Subsection 2 of section 11,
11.
which clearly bars revision.
Revision.
There is no such corresponding provision barring revision as such.
Yes, that is.
That's correct?
Yes. You could.
Lot of corrections are to be there, but this is what I thought that I should share with you, that I have dictated it.
I will share the soft copy with you.
Sorry?
I will share the soft copy.
Yes, please do it at the earliest. Earlier the better. I have not referred to your full bench. Not required.
Other submission.
Yes, other submissions.
Item 5, the LPS
उसका
258.
जजमेंट का सेट दीजिए. अभी इनका केस में चलो.
Item 5, the LPS 2586 of 2023.
Have you examined?
Yes.
Is it maintainable?
There would be, let's say, it would be subject to some discussion
Okay.
because
All right. We'll just wait
Yes.
for something. Who is for the petitioner in this case? इसमें केस नंबर क्या लगता है? WPS नंबर ऑफिस नोट बना दिया है ना इसका लिस्टिंग के लिए? नहीं ऑफिस नोट तो होना चाहिए ना. Submitted before the bench for orders. Bench slip से आया है ये. तो कैसे आया है? Some office note has to be there. बिना ऑफिस नोट पे कैसे? Did you mention this case that there is an error?
No, yes.
आप इसका ऑफिस नोट बना लीजिए ना. ऐसे कैसे होगा? बनवा लीजिएगा, ठीक है. WPS number 2586 of 2023. The matter has been listed at the instance of the office by indicating that the case number in paragraph 4 of the order dated 9th of May 2024 has been wrongly typed as WPS number 2583 of 2023 instead of WPS number 2586 of 2023. Peruse the records. The orders, the case number WPS number 2583 of 2023 is directed to be read as, in paragraph 4 of the order dated 9th of May 2024 is directed to be read as WPS number 2586 of 2023. Office is directed to carry out the necessary
May I indicate
correction in order dated 9th of May 2024.
May I indicate one thing, Mrs. Subject? In paragraph number 4, you will say that order you will see the error pointed out by land council, the petition appears to be correct. Accordingly, name of Mr. So and so was directed to be deleted also in the original order.
Yes.
That has also not been deleted in the original order. In the original order, on the net it is appearing, you will see.
ओरिजिनल में कैसे होगा ये? तो फिर सब्सिक्वेंट ऑर्डर के साथ ही आपको पढ़ना पड़ेगा।
मतलब वो तीन और निकालना होगा।
क्या चीज निकालना?
Certified
तीन
copy-
ऑर्डर आप नेट से नहीं निकाल सकते।
नहीं मतलब सर्टिफाइड कॉपी तीनों के लिए नहीं लेना पड़ेगा।
ये क्या है ऐसा ऑर्डर जिसमें आपको क्या चीज के लिए सर्टिफाइड कॉपी चाहिए?
ओरिजिनल ऑर्डर 12/4 का निकालते हैं ना मैम,
हाँ।
वैसे तो उसमें आप अब ये तीनों ऑर्डर निकालना पड़ेगा इसलिए।
निकालना ही पड़ेगा।
ठीक है, एज यू विश।
Just a minute. ये डिलीट करने का जो ऑर्डर था तो नेट में नहीं करेक्टेड दिखेगा। नेट में नहीं, वो अपलोड हो चुका है ना, उसको हम लोग चेंज नहीं कर सकते। ठीक है, आपको तीनों ऑर्डर ठीक।
Item 6, Criminal Vision 377 of 2024.
Actually, we'll come to the order of the division bench of the Jharkhand High Court, which was given to us yesterday. Now, if we see the paragraph, because I have gone through the entire judgment, it mainly concerns the interim order which was passed under section 24 of Hindu Marriage Act. And the court has held that the appeal is not maintainable against the interlocutory order. Now, let's see the order, if it is taken into consideration, the Delhi High Court's division bench judgments order, which I had
The
supplied.
first you address on this.
Because that is why I'm coming on the same point, because what has happened, we
The-
were of the
What was interpreted was section 19 of the family.
section 19, yes, section 19, the provision 1 and 4, whereby it bars the applicability of appeal in the following in some of the cases. Now, what will be essential if I take that relationship directly to the Delhi High Court's judgment, which I had given yesterday. Because what has happened, the Delhi High Court judgment has also relied upon Jharkhand High Court's judgment, division bench judgment.
Which one? The same one?
No, it's a different judgment where I could also get my hands over it. This is one single page order, this is also a reported judgment. Paragraph, if may have the Delhi High Court judgment, paragraph 25. Manish Agarwal versus Seema Agarwal's case.
Just a minute. First, let us see Tinku Prasad Sahal.
Tinku Prasad's order is there?
Tinku Prasad Sahal, open that.
Yes.
It
If
was
I
under
read,
section.
yes, if I read paragraph 3, even the opening paragraph would be important because that is the gist.
That's
Whether-
right. You come to section 19(4). It is quoted in this judgment.
Section 19(4).
It is at internal page 16.
I have the act. Now,
You
section
read.
19(4) reads, with your permission,
Yes.
the High Court may, on its own motion or otherwise, call for and examine the record of any proceeding in which the family court situate within its jurisdiction passed an order under Chapter 9 of the Code of Criminal Procedure, it's in 1973, for the purpose of satisfying itself to be the correctness, legality or propriety of the order, not being an interlocutory order, and as to the irregularity of such proceeding. Now, this explanation part, that it can enter into revision if it is not being an interlocutory order. This explanation is given in the Delhi High Court's order. Why? Because Delhi High Court's order came to a finding that the interlocutory order also decides the right of the parties substantially. But on the contrary, our division then says that the interlocutory order does not
Yes.
adjudicates upon the right of.
We are governed by our.
Yes, well, that is the difference. But then again, just one would be what would be important if the Delhi High Court judge in paragraph 17. If I will take only on the paragraph 17, because this Delhi High Court on the second page, if the paragraph 17 starts with the internal page 228. If I may take my leadership to page 229, Roman 3. There is a reference of a case, Nasreen Begum versus State of Jharkhand.
Yes.
Nasreen Begum of the State of Jharkhand, 2000 Criminal Law Judge 326, Division Bench Judgment of Jharkhand High Court. The short order, it was held that section 19(4) of the said act makes special provision of revision with regards to orders passed under section 125 CRPC, and thus revisions would like.
That's right.
And
this
this
is not. This.
And this is one of these orders, because what I am dealing, my case is against the interim maintenance granted under section 125.
This
In Tinku's
was
case,
not. This was not interpreting the Family Courts Act.
well, the further interpretation of interlocutory order is in paragraph 26, 25
You
and
see,
26.
this particular order which has been passed is certainly binding on us. We will not go to any other
No,
court.
there is another division bench order which is
We are
also
not, where
contradicted.
is that Narseen Begum case?
Yes, this is
Yes.
one single page order, this is also reported. So I could only take out the printout. But I say, Malad, this is also not touching on the core issues of 1940. Let's see,
There is no
paragraph
discussion. You see, in par it appears that
2 and 3. Because that discussion regarding interlocutory order is not there.
it's not there. We have this judgment which is a full-fledged judgment. So if you have any grievance, go to the division bench. We can't do anything. We are bound by the judgment passed by our High Court.
So giving that reference, giving that reference that the interim maintenance shall not be, because the court
And then this particular judgment has thereafter referred to the judgment of Rajneesh versus Neha.
registration was Neha is
Therefore, you see the touchstone of an interlocutory order is, or an intermitting order is, that it should not terminate the proceedings, right?
Yes.
Grant of interim maintenance does not terminate the proceeding in any manner whatsoever.
in any manner.
Merely because some valuable right is there, that does not mean that it will be a revisable order. It should terminate the proceedings in one or the other.
One order
manner.
should be final.
So therefore, it for every order, right? Order taking cognizance or any order is final at its own stage, right? So this particular order of interim maintenance also does not terminate the proceedings in any manner.
No, what would be not be binding on you would be Delhi High Court judgment, because Delhi High Court judgment is finding and the finding
You
of
should
our
have filed it
court.
before Delhi High Court.
No, the finding is totally
No.
contrary. Because
Maybe
our
you
court
see,
says that interim
our-
order is not, it is
Yes,
cannot
and
be.
it also refers to the judgment of the Honorable Supreme Court, which says that it is just at the interlocutory stage or completely.
So, no,
So
I think we are binding by this our
yes,
High Court
simple.
judgment.
We are
So
bound
that
by
only
this
it is on
judgment.
the maintainability issue that it is the revision would not be
Yes,
maintainable.
revision is not maintainable. Revision is not maintainable.
So giving reference that it is ordered that it is not maintainable.
First appeal number criminal revision number 377 of 2024. Counsel for the petitioner has submitted that an objection has been raised by the office that the present revision is not maintainable against an order of interim maintenance. In that connection, are you there? आपकी तरफ से लिखा देते हैं कि she cited this. In that connection, the counsel for the state has referred to judgment passed by this court in first appeal number 18 of 2021, decided on 18/4/2022, and has submitted that it has been ultimately decided by this court by referring to the judgment by referring to numerous judgments, including the judgment passed by the Honorable Supreme Court in the case of Raziz versus Neha, reported in bracket 2021 bracket close 2 SCC 34, that the order of interim grant of interim maintenance does not crystallizes the right of the parties in any manner. She also submits that by virtue of grant of interim maintenance, the proceeding does not terminate in any manner, and therefore the order is interlocutory in nature and the present revision is not maintainable. यही है इनका. To this,
And
counsel for the petitioner has submitted that contrary view has been taken by
Delhi.
Honorable Delhi High Court.
Well, but the reference of the Honorable Coordinate Bench, Division Bench of the Jharkhand High Court should also be put.
The learned counsel has also referred to order dated 18th of July 2005, passed by Honorable Division Bench of this court,
First appeal number 18 of
Yeah,
2021.
in first appeal number
18 of 2021.
18 of 2021 वो भी नंबर भी नहीं दिख रहा है इसमें.
हमारे पास है.
In first appeal number 18 of 2021 to submit that the order passed in a proceeding under section 125 within bracket 125 of CRPC is and that against the order passed under section 125 CRPC revision would lie and the appeal is not maintainable. This court has gone through the aforesaid order dated 18th of July 2005. From the perusal of the said order, there is no indication as to whether the said order does not indicate as to whether the revision would lie against interim maintenance, right? There can be no doubt that revision would lie against final orders passed under section 125 of CRPC. This court further finds that the subsequent judgment of this court in the case of Tinku Prasad Saha in first appeal number 18 of 2021 clearly holds in paragraph 49 that grant of interim maintenance is just a temporary arrangement and it terminates upon final judgment and therefore it is interlocutory in nature. Paragraph 49 of the said judgment is quoted as under. In view of the aforesaid judgment, this court is of the considered view that the present revision against grant of interim maintenance is not maintainable. And accordingly, this revision is dismissed as not maintainable. इसमें कहीं नहीं है ना interim maintenance का बात.
उसमें interim maintenance का बात
नहीं है.
नसीम बेगम वाला केस.
नसीम बेगम में नहीं.
उसमें नहीं है.
नहीं.
Section 19(5) of the Family Code also says, my lord, no revision or appeal shall lie in any judgment from the Family Code Act. Section 19(5) of the Family Code Act.
तो यहाँ पे 125 का जितना मेंटेनेंस होता है मैजिस्ट्रेट कोर्ट से.
Magistrate court से. तो
And this has been filed against Family Courts Act.
is Family Code Act.
इसमें because
इसमें
section
Family
19
Courts Act से आया है.
हाँ family court
Family
से
Code से आया.
family court से आया.
वहाँ जहाँ लिखे है ना रिविजन वुड लाई तो उसमें लिखना उसमें वो लिखने का जरूरत नहीं है ना. Order passed under section 125 of CRPC, final orders, right? Appeal would lie. Appeal would lie under the provisions of Family Code, section 19 of the Family Code.
Family Code.
And the present revision against the interim maintenance is not maintained.
Then again, the conflict would be whether it is against the final order against 125 there would be an appeal.
Magistrate अगर करते हैं तो.
हाँ और अगर 125 में अगर interim maintenance दे रहे हैं तो revision is not maintainable.
Revision is not maintained.
But then अगर we should also not give this that there is appeal also lies.
No, appeal also will
Or
not
appeal
lie.
because the in
Appeal
the
will not
Tinku
lie. Even appeal will not lie.
paragraph 52 of Tinku
Yeah,
Prasad says that ki
I have
either
already held that it is an interlocutory order.
Yes.
Therefore, appeal will
yes,
not lie.
Yes, but that indication will also be not given that appeal
It will
also
be
lies.
there.
Yes, grateful.
These procedures are important. Na? Then
Yes.
people are guided by that. इसीलिए कल मैंने
Because the
बोला
Delhi
था।
High Court judgment was totally discussion was on the point because the interlocutory orders interpretation is totally different. But then again, unfortunately, it's different than our court. Grateful.
We We are not subordinate to any other high court, isn't it? Yes, you have authorized me that teacher. So yeah, this will happen. Okay.
From daily list for orders item 3, the local 3912 of 2022.
Yes, petitioner,
Yes, ma'am, substituted notice.
you
Service
have
of
filed your
notice.
petition.
There are, yes, supplementary affidavit has been filed showing the substituted service of notice. Yet respondent, it appears that they have not filed their one.
For substituted service of notice, for henceforth, you should always file the original newspaper. Always. Right? That should always be there. Because it forms a part of the record. You do not know what time the
Yes,
respondent would come or their legal heir would come and say something.
My lord,
So,
if
service of
required, I'll
notice is
file-
complete?
Yes, yes. ma'am. My
The
lord, if
admission
required,
letter?
I can file the original
Not
copy.
required.
There is an application for stay, my lord, that's why I suppose it has come under the heading notice.
There is I have specifically stated that the original newspaper publications are to be made. You bring it on. You should find it.
2 weeks time.
WPL number 3912 of 2022. Counsel for the petitioner prays for and is granted time till 9th of July to file the original papers of publication of notice. Post on 10th of July. रिकॉर्ड्स नहीं आया इसमें स्टे क्या करना है रिकॉर्ड्स मंगाते हैं ना
मेरिट्स पे ही नेक्स्ट बहुत छोटा सा इशू इन्वॉल्व है
That's in the meantime the records we called for from the concerned court. Let this order be communicated through fax.
For press filing item 4, Universal 8882 of 2023.
Yes, petition.
Actually, in this case, I have challenged the discharge order passed by the Honorable Court below, mainly on two grounds, Your Lordship. The first ground is that the entire case diary has not been appreciated properly, and which may require the lower court records to be.
What has not been? Where is your? So you are. Who are you?
I am, if I may take Your Lordship to the FIR, Your Lordship, that is at page 19 of my petition.
What is it that has not been appreciated?
The entire FIR deals with a case that was registered, wherein it has been alleged that some refilling of gas cylinders were taking place, and I being the there are two petitioners in this case. I being us being the driver and the helper, we had just gone to deliver the cylinders to the place, and a raid was conducted on the premises of the third accused person, and we were apprehended from the spot, and the cylinders that were loaded on our vehicle, they were also seized. There was also a fourth accused person in this case, Your Lordship. So
Your petition for discharge has been rejected.
yes, sir.
Right? So there is no material against you. Is it your case?
My case is that one very pertinent material
What is that material?
that is at Annexure 3, page number 38, Your Lordship. This is the certified copy of the police report, and this was brought on record when the cylinders were released on the instant of accused number 4, who was the owner of the Preet Gas Agency. If I may allowed to read your option. उपयुक्त प्रसंग एवं विषय के संबंध में सादर सूचित करते हुए कहना है कि प्रीत गैस एजेंसी का हिमपुत कंपनी का 57 गैस सिलेंडर की मांग की गई 5 बिंदुओं का प्रतिवेदन निम्न प्रकार है। प्रीत गैस एजेंसी के कागजात का अवलोकन किया। अवलोकन से ज्ञात हुआ कि प्रीत गैस एजेंसी का प्रबंधक सुविंदर कौर, शी इज ऑलरेडी डिसीज्ड, पति सतपाल सिंह, पता किशन सिंह कॉलोनी, होटल प्रीत पैलेस, थाना चुटिया, जिला रांची है। जब्ती सूची के अनुसार कुल 96 गैस सिलेंडर प्रीत कंपनी के हेमकुंड गैस सिलेंडर जब्त किया गया है, जबकि प्रबंधक द्वारा 57 गैस सिलेंडर का मुक्ति हेतु किस परिस्थिति में प्रबंधक द्वारा 96 गैस सिलेंडर में मात्र 57 गैस सिलेंडर का
it can't be. You see, you cannot have the selective appreciation of material. There are material against you. You are the driver and the helper.
And the driver and the helper.
Yes.
Just I will read one more line that जब सिलेंडर का फोटोग्राफ तैयार कर सबमिट की जा रही है, मोस्ट पर्टिनेंट सभी कागजात वैध हैं एवं अद्यतन हैं। प्रीत गैस, दिस सभी कागजात, I have been adducing this कागजात and every दस्तावेज at every point of time, but that has been not specifically dealt in the discharge order, and this police report nowhere finds mention in why this has not been considered in the discharge order. I had and one criminal revision number 384 of 2023, the web copy I have annexed at page number 39, your lordship. This entire order sheet also at para 9, your lordship. However, the learned court below has rejected the prayer on the ground that DC Ranchi is empowered to release the same. In this case, your lordship, Essential Commodities Act was not attracted. So, considering the fact the charge sheet has been submitted against the petitioner under section 4.
You place the impugned order. You see, in revision, impugned order is the most important thing.
Yes.
You are not placing everything the impugned order and you want to narrate the entire story. You place the impugned order.
In the impugned order, your lordship, these submissions have entirely not been recorded, your lordship.
Where is your petition for discharge?
I have not added, but it is part of the lower court record.
We are not here to call for records unnecessary.
Even in the case diary, your lordship, entire thing is just a reproduction. Only there were no independent witnesses. Only police personnel were there, and they have merely reproduced whatever the.
Who is the informant of the case?
Informant himself is a police personnel, your lordship.
They intercepted the vehicle.
They intercepted the vehicle when I was delivering the cylinder. And one more thing, your lordship.
Just a moment. Intercepted the vehicle.
Yes, your lordship.
And found that you were not accompanied with papers.
I was not accompanied with the paper at that point of time. That was their only availment at that time, and they did not give me any time to produce the paper which.
You are supposed to carry papers while in transit.
I am part of a parallel marketing system.
Maybe whatever with the
I was carrying some papers regarding the challans and all, but I was not carrying the trade license and everything else, which could have been called for at the state. I have been annexing all those things in the trial, but
so these things you have to produce at the stage of trial.
If I may be allowed to read the
That should
infused order resolution.
The key
I-
criminal revision number 882 of 2023. Counsel for the parties are present. This revision has been filed for the following relief. The learned counsel for the petitioner submits that the petitioners are the driver and khalasi. Driver and khalasi nahi.
Driver and helper.
Driver and helper in connection with the vehicle which was intercepted by the police on 8/9/2019, and an allegation of theft was, and the case was instituted against the petitioner for offence under section 413, 414, 420 and 120B of the Indian Penal Code. The vehicle was intercepted on the basis of secret information of one Sandeep Kumar Sahu, alleging illegal refilling of gas cylinders in his house. The informant saw different cylinders of various companies such as Indian, Bharat, HP Gas and Preet Gas Agency. Himkund cylinders were being used for refilling. The informant demanded the papers of all the cylinders of various gas companies, but Sandeep Kumar Sahu failed to produce the relevant documents, and at the same time, the
May I just
vehicle
place-
owners were, the petitioners were apprehended. The learned counsel submits that although the required papers were not produced at the time of the seizure,
May I just place one thing?
yes, but the same was subsequently produced. But this aspect of the matter has not been properly considered by the court by refusing to discharge the
And the
petitioners.
papers were not demanded from me, it was demanded from Sandeep Sahu.
The learned counsel has also submitted that the papers were not demanded from the petitioners, but it was demanded by Sandeep
Sandeep Sahu, accused number 3.
Sandeep Sahu, who was also a co-accused in the present case. Counsel for the opposite party state has submitted that these matters are essentially matters of trial, and the impugned order refusing to discharge the petitioner does not call for any interference. They submitted that impugned order has been passed on the basis of materials collected during investigation. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that apparently at the time of search, the required documents were not produced by one or the other accused person, and the petitioners happened to be the driver/helper of the vehicle involved in the present case. This court further finds that the learned court has referred to the materials collected during investigation and has recorded that the plea raised by the petitioners were apparently relating to his defense and has refused to discharge the petitions. This court is of the considered view that the impugned order is a well-reasoned order, the same does not call for any interference.
If I may be allowed to withdraw I'm sorry.
After some argument, the learned counsel for the petitioner seeks permission to withdraw this petition. This petition is dismissed as withdrawn. Sign करिए. You are the advocate on record.
Item 5, Juvenile 1093 of 2023.
Yes, petitioner.
This is the against maintenance order. And I have filed also on IA petition 5910/2024 for a stay of the
What is your ground?
grounds, Lordship. And the impugned order, there is no a specific assessment has been given about the assets, and merely on the presumption has been held that the petitioner is liable to maintenance and has been
How much of amount has been fixed?
5,000 has been given. Even the Rajneesh versus Neha judgment has been reported, but which has not been followed in judgment.
Your wife has some source of income?
Even the petitioner
Does
is
she
not.
has any source of income? Is it
No.
your case that she has source of income? Where is your case?
Lordship, because the petitioner was not able to file the show cause before the learned court below, which has been debarred, and due to this reason, the petitioner was not able to adduce any evidence on this ground. Lordship.
What is your case?
The case is that the
You see, amount is very small amount. How much
the
is
small amount is not much, Lordship, but the finding in Megali page number 35.
Your Lordship, I am attending for this date, and Your Lordship, I may permit to be another voting now.
Why are you here? You should not have been here.
Your Lordship,
ये बताने के लिए कि बीच में बोलना है कि दूसरा कोर्ट में जाना है. I will not record your appearance. If you want to go, you can. You are not required. Otherwise, also maintenance में state का क्या काम?
Lords, page 35.
Yes.
Judgment जो नीचे है, I may profitably quoted a passage from the judgment rendered Falna, Delhi High Court, an able-bodied young man who is to be presumed to be capable of.
You did not file your show cause.
No, not has been given.
So, by which order you were debarred?
Order dated. This fact has been mentioned in the impugned order, page number 21, order 3/3/2023. No, notice has not been sent to the
Your
opinion.
Lordship, notice is required in this case.
Page number?
Page number 21, para 3 of the judgment order.
Yes.
Upon perusal of the record, it appears that the respondent, who is the husband of the petitioner, namely Pramila Devi, appeared on 8/8/2022.
So, what is the illegality in this?
Legality is.
There is no illegality. If you are debarred from filing your show cause, you will not file your show cause. Simple. What is your explanation for not filing the show cause?
But
And why should we interfere in such kind of an order?
two grounds.
Yes.
First, the assessment whether the petitioner was liable has to be reasoned order, which has not lacking in this case.
That's
Page number 35 and 36. Merely on the presumption has been
Are you a government servant or you are not a government servant?
government servant.
He is a
So,
government servant.
what else? What else do you need?
But the order has to be reasoned order.
We'll see that. 7,000 रुपए मेंटेनेंस के लिए क्या रीजन चाहिए?
एंड सेकेंड इज जो बच्चा के लिए है वो मेजर हो गया था, उसके बाद भी उनको अवार्ड हो गया है बच्चा को मेजर पर. जबकि उसका मैरिज भी हो चुका है.
कहाँ से बोल रहे हैं? She must have deposed now. What is the age of the child?
Not has been stated.
Not stated.
Not stated. Even I have a deposition also. मैं यह केस अपने और अपने बच्चे विशाल के भरण पोषण के लिए अपने पति पर की हूँ, कहीं पर भी नहीं है.
Minor child लिखी तो है minor.
Minor child word has been mentioned, but
Minor
the
काफी
age-
नहीं है क्या? You
My-
file your 127 petition maintenance का order का modification के लिए. File it.
मेरा तो कहना है कि illegal order है. On the lacking of the reason order has not been passed.
That's it.
This is the
That
my
is all?
contention.
देखिए.
And second is the judgment has been referred in Rajnish versus Neha, but which has not been followed.
No, it need not be. In all the cases where the wife does not have any source of income, and only 7,000 rupees has been fixed, and it is not in dispute that you are a government servant, what else is required? Why should we interfere? Rather if the wife comes by saying that she has been given less maintenance, then we can think. We do not know. But just a meager amount of rupees 7,000 has been fixed. You are not even disputing the marriage.
No,
You
no.
are not disputing that you are in government service.
No.
That is all. देखिए, criminal revision number 1093 of 2023. The counsel for the petitioner and the counsel for the state are present. Counsel for the petitioner submits that the impugned order is a non-speaking order with regard to the assessment of quantum of maintenance. The learned counsel has further submitted that the petitioner was not granted the opportunity to file his show cause, and therefore the impugned order calls for interference. During the course of arguments, it is not in dispute from the side of the petitioner that the opposite party number 2 is the wife of the petitioner. And the wife had claimed maintenance for herself as well as her son, namely Vishal Das. As well as son, namely Vishal Das. However, counsel for the petitioner has submitted that Vishal Das is major. This court finds that it has been specifically recorded. After going through the impugned order, this court finds that it has been specifically recorded in paragraph 3 that the petitioner appeared on 8/8/2022 before the learned court, but failed to file his show cause. And after giving proper opportunities, he was debarred for filing show cause on 3/3/2023. And it was only thereafter the court proceeded to record the evidence from the side of the applicant. Did you cross-examine her?
No. Even cross-examination has not been given.
You have not been debarred from cross-examination.
No. As per this order,
Yes.
but the
During the course of hearing, the learned counsel for the petitioner has not given any explanation as to why the petitioner did not file his show cause in spite of repeated opportunity given to the petitioner. It is further not in dispute that the petitioner is a government servant under the Municipal Corporation Kolkata. The paragraph 6 of the impugned order reflects that the petitioner had filed maintenance for herself and one child, Vishal Das, but after some days of filing maintenance petition, Vishal Das became major and the name of Vishal Das was deleted, and there was no claim for demand of maintenance for Vishal Das. Right? Thus, the argument of the petitioner that Vishal Das was major has no bearing in the present case. And the impugned order also reflects that no maintenance has been awarded for the son, namely Vishal Das. This court further finds that the learned court framed five issues at paragraph 8, which are as under, and determined each of the issues by referring to the evidences on record. And while with regard to issue number 1, the learned court recorded that the applicant was the legally wedded wife of the petitioner. The learned court also recorded that with regard to the learned court has also considered the point raised by the applicant that the petitioner had kept another lady and that she proved that the petitioner had refused and neglected to maintain the applicant. With regard to determination of quantum of maintenance, the learned court recorded that the learned court also recorded that the applicant was unable to maintain herself. With regard to quantum of maintenance, the learned court has considered the materials and also the judgment passed by Honorable Delhi High Court reported in AIR 1968 ने reported in ये कौन सा है judgment का citation नहीं लिखा हुआ इसमें in Chandra Prakash Bodhraj versus Shida Rani and has also considered that an able-bodied young man has to be presumed to be capable of earning sufficient money and is under an obligation to maintain his wife. And ultimately, by referring to the fact that the petitioner is a government servant, fix the compensation, fix the maintenance of rupees 7,000 per month for his wife. This court finds that the improved order is a well-reasoned order. The same does not call for any interference. Accordingly, this petition is hereby dismissed.
Liberty to file 127.
वो liberty आपके पास है.
Your Lordship, my appearance.
Counsel for the state is present.
Item 6, Criminal Division 1351 of 2023.
Yes, petitioner. Yes.
In the order of discharge, page 24, there is 7/9/2023. The civilian is referred. It's my ground lord that the FIR is launched after the delay of 5 years, 6 years. The offence took place in the year 2016 and the FIR is launched.
Yes.
And both the parties are majors. At the time of informant was aged about 37 years and the petitioner was aged about 32 years, 28 years. And both are consenting parties. In the FIR, it has come, the relevant portion and not the candy permit. 3 places have been mentioned that the rape have committed in Sanskar Hotel, Baryapti on 2 occasions. And in the investigation report, it has come that such person have never stayed in those hotels. And the third thing, they have accompanied to a hotel in Bistupur, Jamshedpur. And in the investigation report, it has also come that hotel was destructed. And at the time of occurrence, that hotel was not existed.
What is the date of occurrence?
It's a date of occurrence 5/2/2022. In the
Date of occurrence, we are not the date of occurrence.
2016.
But then,
at page 19, the first following the concluding portion. मुझे होटल संस्कार में शब्दाम हमेशा लेकर जाया करता था. वर्ष 2016 से लेकर 2021 तक की होटल संस्कार की रजिस्ट्री में हर बार एंट्री हुई. There is no entry. And this has also come in the FIR that at the pretext of marriage, both have built their relationship and the relationship was continued for 5 years with their consent. And there is no evidence or material on the court in the FIR as well as in the investigation report to show that the promise was false marriage and at the time of solemnizing, performing this act, there was any bad intention or there was intention of cheating of the petitioner. And
there is an allegation that you also took her pictures.
Yes, Lordship.
Those allegations also there.
That has not come in the diary. All the allegations are vague.
That is in
and exactly in the same and similar.
If the allegations are vague, these could be a ground for bail and it could be a ground for acquittal. But can it be a ground for discharge? It cannot be a ground for discharge. These are very serious offences.
Are
And the
you
delay, has
out
it
of
become
line?
barred by limitation?
And out by 9.9%.
Merely on account of delay in a case under section 376, can you be discharged? इतना सीरियर है, आप बताइए, आप हमको 6 साल का डिले के कारण आप डिस्चार्ज हो जाइएगा.
From the face, out of
And they are
96%.
consenting party or they are not consenting party is something which is essentially a matter of trial. आपका लेडी का कंसेंट था कि नहीं था, क्रॉस एग्जामिन आप करेंगे ना उनको, तब आपको पता चलेगा कंसेंट था कि नहीं था. ऐसे कैसे पता चलेगा? Without cross examining the victim,
Yes.
how will this court come to a conclusion that she was the consenting party?
On the factum aspect is concerned, although this is true, as Lord is going
You
in the
want to,
direction
are you still willing to press this application?
So the IU is submitted out of 9%, 8% have been exonerated from the case. 8% have already been exonerated from the case, except me. The charge sheet has been submitted.
That's right.
So my only humble favor. But the revision is
Her
also,
statement under section 164 was also recorded.
One-
उसका कोई value नहीं है. 164 statement has been recorded. It
Yes.
has no value.
So, correlation of
जब
the other
victim
facts.
का 164 statement record हो जाता है ना, discharge बहुत मुश्किल काम है.
Also one thing. So, only Lordship is going in the right direction,
ये
but there is
काफी
a
है
limited
कुछ
scope
करने
in
का
the
जरूरत
revision. But when the prime officer, but there is no any
164
cogent material.
statement has got sufficient value in the eyes of law. It is not an ordinary chit of
One
paper.
general of the
161 का statement नहीं है ये. 164 का statement.
Take your Lordship may kindly consider one order of this coordinate bench. It's, after recording of the statement of 164 CRPC, the revision has also been allowed. By discharging
Has
the
it been
accused.
said
In
that
similar, exactly in the
164
similar case.
164 has no value? Has it been said?
164 statement was recorded in this case.
That's right. There may be many cases, we do not know. Every case has its own
See,
facts.
each and every case has its own case.
That's it. Criminal
Sir,
revision number
court-
1351
Lordship
of
may
the-
kindly consider what's one Supreme Court judgment exactly on the same footing. Exactly covered, squarely covered.
Line है?
Yes, yes, yes.
दिखाइए.
Almost Sri Bhavan Pawar case was the famous case, the milestone judgment.
Yes.
This is part of 16, 17 and 21.
Read it.
It's only one.
Read it. पढ़िए.
See, copy.
This सब case.
And one thing is also covered. What's the division is allowed. You also whatever thought. But say it has come below. But say in an astonishing matter, how the fact is believable or not believable. This is also considerable by the court. The court could not be the mouthpiece only to see the facts only. The court has to see the facts in the entirety to eliminate the some misuse of the process of law. It's
Is it your case that there is no material against you? Is it your case?
so prima facie there is no material.
Prima facie there is no material means what? It means no material.
Squarely on the same basis, my division is also admitted allowed with us. One division.
आप अपने पास तो रखते नहीं है, भेज देते हैं कोर्ट को कि हम पढ़े हैं पूरा
Sorry,
करके.
excuse me, sorry, just हमको मिला तो
किस तरह का आपका मतलब कंडक्ट है, हमको समझ नहीं.
I'm extremely sorry.
heard the learned counsel for the parties. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that there is enormous delay in filing the FIR, inasmuch as the case has been filed after 6 years and both the parties were consenting parties. He submits that the he submits that the learned court has wrongly refused to discharge the petitioner. The learned counsel, appearing on behalf of the state, has opposed the prayer and has submitted that there are serious allegations against the petitioner and the statement of the victim was also recorded under section 164 of CRPC, and it has been recorded in the impugned order that the victim portrayed the horrendous and nasty act of the petitioner in a statement under section 164. The learned counsel submits that the delay appears to be well explained in view of the fact that, as per the FIR, photographs were also taken by the petitioner. At this, counsel for the petitioner has referred to judgment passed by this court in Penal Revision number 32 of 2022 and has submitted that in the said case also, statement under section 164 was taken into consideration, but still the court found that no case under section 376 of IPC was made out, and what was made out was only offence under section 4 of Dowry Prohibition Act. After hearing the learned counsel, यही आपका बस? That's all?
And one judgment also.
Which one? Supreme Court.
Yes.
The learned counsel has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2019, bracket close 9 SSC 608, paragraph 16,
17 and 21.
17 and 21. To submit that in case of consenting parties, there is no question of proceeding for offence under section 376 of IPC. Okay? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that there is serious allegation made against the petitioner in the first information report, and the sequence of events have also been narrated in the said report. It has also been alleged that the petitioner used to take he used to do videography of the victim further appears from the record that after investigation, the charge sheet was submitted and the petitioner had filed their petition. Charge sheet was submitted and for offence under section 376 within bracket 2 within bracket F 417 read with section 34 of IPC. Our charge sheet was submitted under section 376 within bracket 2 within bracket N 376 within bracket 2 within bracket F 417 354 read with section 34 of IPC. It further appears that at the stage of investigation.
In seeking to withdraw this application with the confirmation of the
No,
lordship.
I will not permit that. From the perusal of the impugned order, it appears that a statement under section 164 of CRPC was also recorded, which and the petitioner had and the victim had supported the allegation. The learned court considered the materials on record and refused to discharge the petitioner. The findings of the learned court is as under. This court finds that so far as the judgment passed by this court in criminal revision number 32 of 22 is concerned, the same has no bearing in the present case, inasmuch as this court considered the recorded statement of the victim under section 164 CRPC, wherein she had herself stated that she had willingly and voluntarily established physical relationship with the petitioner and she was being treated very affectionately by the family members of the petitioner like daughter-in-law. The statement of the victim, such statement of the victim was taken into consideration to set aside the proceedings under section 376 of IPC. However, the court held that the petitioner was to be proceeded for and held that there was sufficient material for offence punishable under section 4 of the Dowry Prohibition Act, which was found by the learned trial court. This court finds that the impugned order reflects that the victim had supported the allegations in her statement made under section 164 of CRPC. So far as the judgment passed by the Honorable Supreme Court, reported in bracket 2019, bracket close 9 SCC 608 is concerned, the Honorable Supreme Court considered the allegations made in the FIR in paragraph 21 as follows. And ultimately quashed the proceedings. The proceedings were quashed under section where the proceeding before the Honorable Supreme Court was arising out of the petition filed under section 482 of CRPC. Seeking quashing of the entire criminal proceedings. In the present case, after investigation, material was found against the petitioner and the materials were supported by the statement recorded under section 164 of CRPC. And therefore, this court finds no reason to interfere with the impugned order and the judgment cited by the petitioner does not apply to the facts and circumstances of this case. Dismissed, communicate.
Sorry.
Auto turn mentioned case item 14. Criminal Vigilance 101 of 2024.
My lord, this application is preferred for bail and the matter is related to POCSO. The allegation is that, my lord, informant's daughter left her house for the college and didn't come back, and upon inquiry,
What is the age of the child?
my lord, at the time of occurrence, the boy was of 15 years, 5 months, and the girl was of 15 years, 3 months. They both were in consensual relationship, my lord.
15 years, 3 months.
Yes, 15 years, 3 months.
They
Girl.
were studying in the same school.
Yes, my lord. They both went to Delhi, my lord, after getting manipulated by the uncle of the victim minor girl, who had assisted her with rupees 30,000 and had threatened her to leave the village, otherwise they both will be killed by their parents. And it has come in the deposition which I have filed by way of the supplementary. My lord, may kindly
If he
see.
was threatened that he will be killed,
She will be killed, my lord.
she will be killed.
Yes, ma'am. At page number 40, my lord, of the supplementary affidavit.
Her statement has been recorded.
Yes, my lord. I have the certified copy of 164 where she has stated the same.
Show me the statement.
Yes,
Where is the social investigation report?
yes, my lord. It is mentioned at paragraph 12 of the impugned order. He has one antecedent and it was due to village politics.
Just a moment.
Yes, ma'am.
कॉलेज में कॉलेज कहाँ से पहुँच गए?
They both were in the same college.
कॉलेज 15 साल का बच्चा कॉलेज में कैसे
No,
पहुँच गया? Yes.
it has been corroborated by the mother also, my lord. I have filed a
That they were
supplementary.
studying in college.
No, my lord, she was not. She is not a studying.
Then this is what she has stated in her
Yes, my lord.
statement.
Out of fear, they went to Delhi, my lord. And after getting counseled by their families, they returned back. The boy had surrendered himself at police station, my lord.
Where is his social investigation report?
My lord, at paragraph 12 of the impugned order at page number 30.
Yes, I need it.
It is stated by the report below. परिवीक्षा अधिकारी द्वारा किशोर न्याय बोर्ड को भेजा गया अभिलाषी का सामाजिक अनुसंधान प्रतिवेदन में है। अभिलाषी का जन्म तिथि 11/5/2008 तथा उसकी उम्र करीब 16 वर्ष बताया गया है। परिवीक्षा अधिकारी द्वारा अभिलाषी का सामाजिक अनुसंधान प्रतिवेदन में यह प्रतिवेदित किया गया है कि बालक एवं उसके पिता पर पूर्व से बगोदर थाना कांड संख्या 2/2023 दिनांक 2/1/2023 such and such under such and such section.
एक और केस है आपके अगेंस्ट?
Yes, my lord. It was also due to village politics and land dispute, my lord. It was a counter case where he was named.
That also 307.
It was a counter case, my lord. Apart from this, no case is pending. Yes, okay. 7 months have been passed, my lord. He is still in custody. He is a good student, my lord. I have the mark sheet.
Where is it? सब आप अपने पॉकेट में रखिए।
No, my lord. I
है ना, यहाँ
couldn't
पर-
able to file this.
Why did you not file it?
My lord, that time I haven't got this.
You don't make this query. उसका क्या background है? कितना marks मिला?
85% he had scored, my lord.
In which class is he studying?
Board exam, my lord. 10th board.
Class 10th he has passed.
Yes, ma'am.
When did he pass?
He couldn't able to give his exam of intermediate. It was held in March and April 2024.
क्या करेंगे इसको रख के? इंफॉर्मेंट है यहाँ.
सप्लीमेंट्री भी फाइल किया हुआ है. एक ईयर से एक विटनेस मदर ने इनकॉर्पोरेट किया है.
रिकॉर्ड के बिना नहीं करेंगे ऑर्डर. और आप इसको फाइल करें. बिना रिकॉर्ड के ऑर्डर नहीं करेंगे. ये सब आना चाहिए रिकॉर्ड पे ना. आप ऐसे कैसे 7 months आपकी गलती नहीं है. आप डॉक्यूमेंट्स नहीं फाइल करते हैं. हम आपके पॉकेट से निकाला हुआ डॉक्यूमेंट नहीं कंसीडर करते.
Just because
क्योंकि
of
इसमें कोई
disclosure of
एलिगेशन ही
name.
नहीं है. दिस 164 हैज नो एलिगेशन
My lord,
at all.
disclosure of name की वजह से मैंने फाइल नहीं की. My lord, बाकी सब मैंने फाइल किया. डिपोजिशन विटनेस का डिपोजिशन फाइल किया. My lord.
We'll call for the records. We'll give you bill.
My lord.
Apparently we do not know.
His father is calling you, my lord.
Calling
From
you?
the last 1 month he is calling me. 2 days before he was coming, but
गलती है ना आपकी.
yes, my lord.
क्यों नहीं मेंशन करते हैं केस?
मेंशन किया था, लिस्ट नहीं हो रहा था.
लग तो नहीं रहा है कि
My lord, मेंशन किया था, my lord, नहीं हो रहा.
कोर्ट में बोलना चाहिए मेरा मेंशन स्लिप अगर रिजेक्ट हो तो रिकॉर्ड पे लगा दीजिए. जिससे अगला कोर्ट हमसे पूछेगी क्यों नहीं मेंशन किए तो हम बोलेंगे मेरा मेंशनिंग रिजेक्ट हो गया. हम लोग तो बोलते थे कोर्ट को हमारा मेंशनिंग आप रिजेक्ट करके फाइल में लगा दीजिए. बात खत्म.
He will suffer, my lord.
He will suffer because of you.
Sorry, my lord.
You wait for some time. रिकॉर्ड मंगा.
My
आप
lord,
काउंटर फाइल करें.
it will not happen again, my lord. Please consider this all, my lord. Please. It is my first case, my lord. Sorry.
Actually, 1 week time may kindly be granted in that time. If I
Nothing has come, my lord, apart from all these.
क्योंकि इस तरह से आपका फर्स्ट केस बोल के हम इस तरह से
Sorry, my
ऑर्डर
lord.
नहीं कर सकते ना. We have got some responsibility.
Yes, my
आप ऐसे 164 का केस जो है 164 का आप
Charge
बयान भी
has
इस तरह
been
से
paid, my
लगा
lord.
रहे. कहाँ पर हैं आप?
Yes, my lord. Bagudar. The victim is with his father, her father.
रिकॉर्ड कॉल पर किए बिना ऑर्डर नहीं कर सकते.
My lord, इसके अलावा कुछ नहीं आया. my lord.
अब आपको सेम स्कूल में भी नहीं भेज सकते.
No, my lord, he will not go near the informant or the.
पढ़ाई तो करना है ना.
Yes, my lord.
तो दूसरा
He
स्कूल में
has
एडमिशन
that
करना
amount
होगा.
of regret, my lord. He is regretting for this. Out of fear only they went to Delhi, my lord. And after counseling they returned back, my lord. And also surrendered before police station.
Learned counsel for the parties are present. Counsel for the petitioner submits that the petitioner was 15 years 5 months
Yes,
on the
ma'am.
date of occurrence, and the victim was 15 years 3 months,
Yes, ma'am.
and they were studying in the same school. And out of fear, they fled to Delhi, and the victim has got her statement under section 164 recorded, stating that the money to flee away to Delhi was provided by her uncle. Office is directed to call for the records from the concerned court along with the statement under section 164 CRPC and the social investigation report of the petitioner.
My lord, it may be fixed.
एकदम fixed. डेट बिना फिक्स हुए हैं कोई केस नहीं.
Closed it.
My lord, in the meantime, I'll file counter.
And the state is also directed to file a counter affidavit in the present case. Was this case on 9th of July 24 under the heading of family disposal. Notice ordinary communicated facts.
Item 7, Criminal Division 1453 of 2023.
Yes, petitioner.
Petitioner is juvenile under section 363, 365, 364A, 312, 201 IPC. Petitioner not named in the FIR and name of the petitioner come on the basis of confessional statement followed similarly situated two co-equal persons. Three co-equal persons granted by bail by coordinate bench of this court. And petitioner in custody since 2 years.
आपका सोशल इन्वेस्टिगेशन रिपोर्ट सही नहीं है. We'll call for the records.
Three co-equal persons are similarly situated granted bail in this case.
Criminal revision number 1453 of 2023. Counsel for the parties are present. With the records we call for from the concerned court. Counsel for the state is directed to file counter affidavit in the present case. Record में आएगा वो social including social investigation report of the petitioner. We also file your counter affidavit. At this, counsel for the petitioner has submitted that 3 co-accused have been granted bail. In criminal revision number 1014 of 2023. By order dated 13/5/2024.
उसी में मेंशन है 2 और क्रिमिनल रिवीजन नीचे. Criminal revision number
And
7,
also in criminal revision number
751,
751 and 586 of 2023. By order dated 4/12/2023 and 9/2/2024 respectively. Pose this case on 16 July for final disposal. Communicate.
Item 8, Criminal Division 1480 of 2023. Item 9, Criminal Division 1501 of 2023.
It's a juvenile matter and the records have not been called for. It's a matter relates to 376 of POCSO. And my lord, according to the written report, the victim herself has stated that a love affair was going on in between the parties since last 1 year. And it is said that one mobile was
Age of the victim?
Age of the victim according to the written report 14 years, according to the medical report 16 years.
Age of the petitioner.
My lord, 16 years.
Her statement under section 164 has been recorded.
Yes, my lord. It appears from the impugn order that the statement was recorded. It's my lord's submission and the plea that both are the resident of the same village and there was a marriage proposal from the side of the victim and it could not be materialized on the
We consider it.
My
There been a record to me. That's
My lord, हम भी कह रहे हैं
same order record. Social investigation report or बाकी state to file counter affidavit. You file your counter affidavit. ये आएगा 16 जुलाई का final statement. 164 का statement भी आना चाहिए. 16 जुलाई.
Item 10, Criminal Legend 1571 of 2023.
Lordship, in this case, revision has been filed against the order passed by the court below. I am for the bank, Your Lordship, and the vehicle has been released in my favor, but I have been not allowed to sell the vehicle while it is in my custody, Your Lordship. Though it has been specifically come that I am the registered owner of the vehicle.
How can you be permitted to sell the vehicle?
Because I have valid charge on it, and if my lordship has the entire thing comes under the
Who is the informant of the case?
Informant is one private person, and the case pertains to 302.
That's right. So how can you be permitted to sell the vehicle?
Because
You
the
can't sell the vehicle.
vehicle is hypothecated, Your Lordship.
So,
and I have got a judgment.
if a vehicle is involved in some kind of offence, right?
Vehicle, but in the police report, it has come that the vehicle is no longer needed in the case, Your Lordship.
I do not know. Where is the order of release?
Order of release is as impugned order. Internal.
No. Vehicle has been released. You want to sell the vehicle.
Yes, Your Lordship.
Where is the order of release?
It has, in the impugned order itself, it has been mentioned that the vehicle will be released to the concerned bank, Your Lordship. At internal page number 5 of the order, Your Lordship. If I may be allowed to read, Your Lordship.
What are the conditions of release?
I will read the entire thing.
You read because the
According-
vehicle is always released with some conditions.
Yes, sir.
What is the condition of release?
It would be just and proper to release the vehicle in question in favor of the petitioner bank who is registered owner of the vehicle with this condition that the petitioners are neither sell nor transfer the
Then
said vehicle.
That is a condition of release.
That is what I am challenging, Your Lordship, that this condition does not justify on account that I am trying to sell the vehicle as a bank and I will deposit whatever proceeds that come to in the account of the accused person
you
himself.
you can't be permitted to sell the vehicle like this.
Similar case was considered by Andhra Pradesh High Court, Your Lordship. And one judgment I have also annexed as part of the record, Your Lordship.
This was arising out of a suit.
It is arising
It is arising out of a criminal case. It is a material exhibit.
It is arising out of the.
It is a material exhibit, isn't it?
Yes, it is, but
Yes.
in this case, it is not needed, Your Lordship.
We do not know.
I have annexed the police report. Your Lordship.
That is not sufficient.
It,
That is not sufficient.
it has. Then it will act as a bar. Even if I institute a civil suit to sell the vehicle, this order will act as a bar that I
Certainly,
cannot.
you can't sell the vehicle. The vehicle is involved in a criminal case.
But it has come in the police report itself that the vehicle is no longer needed. It will directly affect my finances, Your Lordship.
So we are not bothered about it. We are bothered about the criminal case. That is a condition of release.
And that's what I am challenging. Your
And
Lordship.
now you are in possession of the vehicle.
I have not released it because of.
Oh, you have not taken the vehicle.
Because इसमें Your Lordship और भी सारा चीज लिखा है कि accordingly to that furnishing indemnity bond, I am willing to give the indemnity bond with one surety and further.
What other judgment are you relying upon?
One judgment.
This judgment, how could you cite this judgment? This is arising out of a suit.
This was the best judgment I could find on the release of vehicle involved in a criminal case. One other judgment
This is not involved in a criminal case. This is arising out of a suit.
It is arising out of a suit, Your Lordship, but the pertinent point to note here was that the vehicle was not being released because it was part of the criminal case, Your Lordship, not being allowed to sell. That is the entirety of the pleading.
In this case?
Yes.
Where is it?
It is at para 5, Your Lordship. And para 3, if I may be allowed to.
Where is it mentioned that because of the criminal case it was not being released? Show us, where is it mentioned?
Yes. I may have got confused.
अब जो इतना कंफ्यूज होते ये सब बात एक बार बोल दिए ना,
इसमें
ये बस हमारे दिमाग में ना आपके कई दिनों तक बैठ जाए। क्या बिना पढ़े कुछ बोलते हैं?
नहीं, ऐसा बात
Yes,
नहीं।
ऐसा ही
इसमें
बात है।
एक जो और जजमेंट है।
When I am straight away telling you on the face of the order that it is arising out of a civil proceedings and not a criminal case, you said that no.
एक और जजमेंट है लॉ 2010 6 SCC 768 पेज।
इसका क्या करें? कहाँ है जजमेंट?
जजमेंट
लेके नहीं आए।
कॉपी नहीं लेके आए।
क्या है उसमें?
उसमें है कि इंश्योरर के इंश्योरर को
Criminal
व्हीकल
case
रिलीज
पे
किया गया।
when a vehicle is a material exhibit in a criminal case, how can it be released?
It is
Yes, कैसे release होगा ये vehicle? It can't be released.
Because that vehicle was seized at the time of occurrence, my lord. In a criminal case, my lord.
रिलीज करने का तो
Release
ऑर्डर हो ही
नहीं,
गया।
वो sale
हमको
करने का
sale करने का मतलब
नहीं हो सकता।
एक बार योर लॉर्डशिप एनेक्शन 9 देख लिया।
Therefore, the court below has passed the conditional order.
एक बार एनेक्शन 9 देख लिया जाए योर लॉर्डशिप, पेज नंबर 37।
क्या है
ये पुलिस रिपोर्ट है योर लॉर्डशिप। इसमें देयर वर सर्टेन क्वेश्चंस पुट टू द पुलिस दैट वेदर दिस व्हीकल का क्या पोजीशन है, वेदर दिस
मुक्त करने में कोई आपत्ति नहीं है, सेल करने में कोई आपत्ति नहीं है, लिखा है क्या? दोनों एक बात है। रिलीज करने में कोई आपत्ति नहीं है।
Then if I go for the release of the vehicle, it will be no use of the bank.
Yes, it is of no use to you.
Then I pray that the conditions may be altered, your lordship.
No, we will not alter the conditions.
Then it may be remitted back to the lower
No.
court for alteration of the
No.
conditions, your lordship.
No, there is no question.
Because that will effect as a direct bar to the SARFAESI Act and as well as to the Contract Act, your lordship.
What bar?
Section 2N of the SURFACI Act, it will act as a direct bar because I will be not allowed to sell a hypothecated vehicle.
You will not be allowed to sell. You file a recovery suit. क्या है? सरफेसी में नहीं रिकवर कर पाएंगे तो रिकवरी सूट नहीं होता है क्या? फिर?
और सरफेसी में आफ्टर अमाउंट 20
क्या
लाख से
बात?
20 लाख से ऊपर का vehicle है.
हाँ तो जितना का भी है, you file a recovery suit. There is no bar. इतना बता. आप चार्टर्ड अकाउंटेंट है ना?
CRPF में ये वाला चीज.
आप चार्टर्ड अकाउंटेंट है कि नहीं?
हम चार्टर्ड अकाउंटेंट.
CAS है, क्या है? कुछ तो है.
नहीं वो दूसरे थे.
वो दूसरे थे, एक ही जैसे दिखते हैं. नहीं कुछ आप रिकवरी.
ये वाला चीज बस फिर मेरे सबमिशन में ये लिखा दिया जाएगा that I may be allowed to sell the vehicle in a recovery. I may be allowed to file a recovery suit against him.
I will not say anything. I am not your advisor. वो है आपका एडवाइजर. इनसे पूछिए, आपको बताएंगे क्या क्या आप कर सकते हैं. सतीश जी इनको जो समझाइए क्या क्या कर सकते हैं. आपका वो पब्लिक डिमांड रिकवरी का भी हुआ होगा. आपका 20 लाख से ऊपर का है तो DRT चले जाइए. उससे कम का है तो आप सूट फाइल कर लीजिए.
And it has also come in the impugned order that the petitioner, the accused person himself has no objection if the vehicle is released in my favor and I sell the vehicle.
उसको क्यों objection होगा? Criminal Revision number 1571 of 2023. Counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner submits that the vehicle involved in the present case is hypothecated to the bank, and therefore the petitioner is aggrieved by the condition put by the learned court that the petitioner would not be permitted to sell the vehicle. Although the learned court has passed an order to release the vehicle in favor of the petitioner bank. The learned counsel submits that public money of the bank is involved in connection with the vehicle loan, and the police has already given a report that they have no objection if the vehicle is released, and therefore the petitioner may be permitted to sell the vehicle and realize the proceeds. He submits that the petitioner shall also deposit the proceeds of the vehicle before the court. यही है. The counsel for the
एक पुलिस रिपोर्ट जो था उसमें जो 4th क्वेश्चन था योर लॉर्डशिप की क्या वाहन आवश्यकता प्रस्तुत केस में अथवा किसी अन्य लंबित केस में आवश्यकता है, तो उसमें भी आया था कि नहीं है. प्रेजेंट केस में भी नहीं है.
That's it. The learned counsel for the state has opposed the prayer and has submitted that. You are for the state?
Yes, sir.
The learned counsel for the state has opposed the prayer and has submitted that the vehicle is an important exhibit and the condition of release may not be altered.
सबमिशन लॉर्डशिप तो गलत हो जाएगा क्योंकि आ गया कि नहीं आवश्यकता नहीं है.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that the vehicle involved in the crime was a hypothecated vehicle, and accordingly the petitioner had filed a petition for release of the vehicle. The impugned order indicates that the learned court had put a condition that the petitioner would not transfer the vehicle to, shall not sell or transfer the vehicle in any manner till the disposal of the case. This court finds that such condition This court is not inclined to modify the condition of release as imposed by the learned court. And accordingly, this court further finds that the impugned order putting the aforesaid condition for release does not call for any interference. क्या stage है?
Stage evidence.
At this, counsel for the petitioner has submitted that the case is at the stage of evidence. In view of the it is sufficient to observe that the learned court shall expedite the trial of the case. Communicate.
Item 11, Criminal Gen 1586 of 2023.
Yes, petitioner.
The reason is this order dated 11/12/2023, Lordship, page number 30, whereby a proceeding under section 144 CRPC, which had already come to an end because period of 60 days had lapsed, that was converted into a proceeding under section 145 without recording any satisfaction, without recording any ground. And if your Lordship may come to page 30, the Lordship may come to just order dated 30/11/2023. May I read?
Yes.
अभिलेख उपस्थापित, प्रथम पक्ष अनुपस्थित, द्वितीय पक्ष की ओर से हाजिरी दाखिल किया गया। धारा 144 दंड सचिन सच की काल अवधि समाप्त हो चुकी है। दिनांक 11/12/23 को रखी। On next date, अभिलेख उपस्थापित, प्रथम पक्ष अनुपस्थित, द्वितीय पक्ष की ओर से अधिवक्ता के माध्यम से हाजिरी दी गई। बाद में प्रथम पक्ष
CRPC. The requirement is that the magistrate should be satisfied.
Satisfied and after recording grounds. So neither grounds are there nor satisfaction is there. In fact, if Lordship may come to, it was written case disposed. Thereafter it has been struck down and written convert proceeding under section 1.
Criminal revision number 1586 of 2023, counsel for the petitioner by referring to the order dated 30/11/2023 has submitted that the proceeding under section 144 of CRPC stood lapsed on 11/12/2023. Stood lapsed, but still the matter was posted on 11/12/2023 and without recording any satisfaction. The proceeding has been converted under section 144 CRPC.
145 CRPC.
Sorry, 145 CRPC, which is under challenge in the present proceedings. Issue notice to opposite party number 2 under registered cover as well as ordinary, under speed post as well as ordinary process, for which requisites be filed before this court by Friday. By Friday plenary, pose this case on 23rd July under the heading for final disposal, office to track speed post delivery and prepare appropriate office note with regard to service of notice. Ordinary process and speed post dono.
Until then, Your Lordship, proceeding may not, because due to election it was not proceeding. Now,
Counsel for the state is also directed to seek instructions and file a contract with this case. 144 खत्म होने के बाद 145 में कैसे कन्वर्ट होगा और सेटिस्फैक्शन भी नहीं है, इन दोनों पॉइंट पर आप अपना इंस्ट्रक्शन लेके फाइल करिए.
Item 12 criminal division 1605 of 2023.
Yes, petitioner. Petitioner.
In this case, Lordship, although copy is not neatly, but as per instruction, Lordship, petitioner is the husband of the opposite party number 2, opposite party, Lordship. And Lordship, he has this tortured her, Lordship, and assaulted her.
इंस्ट्रक्शन मतलब किसका इंस्ट्रक्शन?
Opposite party.
आपकी की तरफ से?
Opposite.
State?
No, state नहीं.
Private party.
हाँ, private. And copy is also not. And secondly, there is a grievous injury. He assaulted the opposite party and there is a grievous injury. By putting her hand in the mouth, Lordship. Many more, Lordship, and her relation also with another girl.
Nobody appears on behalf of the petitioner. Counsel for the opposite party. Number 2.
Number only opposite party. There is no state.
State we has.
State है.
Counsel for the opposite party number 2 is present. Post this case on next Tuesday. Copy हम आपको कैसे प्रोवाइड करेंगे?
Next time.
Item 13, Criminal Regime 19 of 2024.
इसमें एक चीज़ और जरा देखिए ना, स्टैम्प रिपोर्टर को जरा बुलाइएगा इस केस को लेकर।
Lordship, matter related to juvenile charges under section 376, sub clause 3 and 4 also Act, my lordship. Appellant was 14 years old at the time of the crime, my lordship, and he was studying Saraswati Sishu Mandir in class 8, my lordship, before he was arrested, and social investigation report has come in good, my lordship, in para 8 of the interim order which suggests that
Same order, call for the records. बिना record देखे order नहीं करेंगे, along with the social investigation.
social investigation report कल ही आ चुका है.
आ चुका है.
हाँ.
लाइए सर. अच्छा रिकॉर्ड भी आ गया. चलिए बहस करें.
social investigation report which has suggests that, my lordship.
Just a moment. Date of incident बताइए.
Date of incident 12/5/23.
12/5/23.
And appellant was custody since
बताइए.
Since then, appellant was custody, my lordship, more than 1 year, 1 month, my lordship, and social investigation has come good, my lordship. In para interim order para 8 is clearly written, my lordship.
Social investigation report आया होगा इसमें.
No criminal stain of that. Was not involved in any criminal activity and any antisocial activity. The vicar of the petitioner is of his mother, my lordship.
माता पिता बच्चे को छोड़कर मजदूरी करने चले जाते हैं. कौन देखेगा घर में? Who will take care of the child?
माता पिता आ गए.
आ गए मजदूरी करने चले जाते हैं.
फाइनेंशियल स्थिति बहुत खराब है इसलिए गए.
इसीलिए जुवेनाइल जस्टिस होम इसीलिए
आ गए हैं और ऊपर विकार भी बनी है.
विकार बने ठीक है, लेकिन आप ही बताइए बच्चों को छोड़ के आप चले जाते हैं. सारे बच्चों को छोड़कर
हजारीबाग में लोग रहता है, डेली वेजेज लेबर का काम करता है. अब साथ में ही लोग रह रहा है फिलहाल. फाइनेंशियल कंडीशन बस 100 वर्ष में दोस्त.
तो कैसे आप केयर करिएगा बच्चे का? बच्चे का कैसे केयर करिएगा? We are concerned with the.
She is ready to give affidavit, my lord.
What affidavit? कि मजदूरी नहीं करेंगे?
मजदूरी नहीं रखेंगे अपने साथ.
कैसे रखेंगे अपने साथ?
आसपास ही काम करेंगे, घर के आसपास ही. कोई कंडक्ट खराब नहीं है इसका.
Conduct खराब is not sufficient. Proper care is required. Who will take care of this child?
Your parents is ready to keep her full maintain, my lord. Proper care में रखेंगे.
बताइए. किशोर के माता पिता जब इनको छोड़कर जाते थे तब किशोर हेमंत उरांव अपनी कृषि कार्य के साथ साथ दोनों भाइयों की देखभाल भी करता था.
फाइनेंशियल सिचुएशन बहुत खराब था और अभी पढ़ने के लिए
और अपने
बहुत
घर से
पसंद
2
है।
किलोमीटर दूर बैल चराने जाता था।
He was eager to study. Saraswati Sishu Vidya Mandir, he was study at Ghagra. Saraswati Sishu Vidya Mandir. He was eager to study matters.
लड़की का कितना एज था?
14 years at the time of the occurrence.
And petitioner?
Petitioner का age भी 14 है. Date of birth of petitioner was 16/3/2009 my lordship.
Date of occurrence क्या है?
12/5/23. And FIR was 13/5/23.
Impugned order पढ़ी। लड़की का 164 तो स्टेटमेंट रिकॉर्ड हुआ होगा ना?
हुआ है।
कहाँ? रिकॉर्ड पे होगा ना 164 स्टेटमेंट। आपको नहीं रिलीज कर सकते।
Lordship, he has been custody since long time, more than 1 year and one month.
You need to stay back.
And the client is eager to study.
You took the resolution number 19 of 2024. The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner was 14 years of age at the time of occurrence, and the victim was also around 14 years of age, and there was love affair between the petitioner and the victim. He has submitted that the petitioner does not have any other case and he is in custody since?
Custody since 13/5/23.
The learned counsel for the state has opposed the prayer. After hearing the learned counsel for the parties and has submitted that nothing adverse has come against the petitioner in social investigation. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that as per the impugned orders, the impugned orders and the social investigation report, the date of birth of the petitioner is 21/5/2009. and the date of occurrence is 13/5/2023. Although there is nothing adverse against the petitioner in the social investigation report, but the social investigation report reveals that the parents of the petitioner used to leave the petitioner and go out for work and the petitioner used to take care of his other two siblings. He was also studying in school namely Saraswati Vidya Mandir, Nawadi.
एजुकेशन अफेक्ट हो जाएगा उसमें।
The क्या बोल रहे हैं?
एजुकेशन इसका बहुत अफेक्ट हो जाएगा।
कोई बात नहीं, अभी की। At this counsel for the petitioner has submitted that the mother has undertaken.
Yes, mother became the pelvicar of the.
Mother is the pelvicar of the petitioner and she undertakes to take appropriate care of the petitioner. After hearing the learned counsel for the parties and considering the fact that there is nothing adverse against the petitioner in the social investigation report, except that the petitioner was not being taken proper care by the parents, considering the fact that the petitioner is a school-going child and has remained in custody since 13/5/2023. This court is inclined to enlarge the petitioner on bail subject to the following conditions. One of the bailers should be the mother and father of the petitioner.
I'm ready.
The mother has undertaken to take care of the child. The father shall also take care of the child so that the petitioner does not get associated with antisocial elements in the society. The petitioner, further condition, the petitioner regularly attends his school and continues to have his training in computer, which he has been taking in the taking while in custody. ये continue करना है.
Yes,
The probation officer of the district shall furnish the social investigation report of the petitioner in every 3 months. And the first report be filed by the probation officer before the learned Juvenile Justice Board on September 6th, 2024.
You will follow.
25,000 securities. Let this order be communicated through this. The impugned orders are satisfied. ये भी है. Next. पासओवर किसका पासओवर? आपका. कौन करिए सर?
Hospital case second 8 Division 1480 of 2023.
The impugned order is the rejection order of discharge petition filed by the petitioners. In this matter, 11 named accused were registered against whom FIR was lodged with respect to offence under section 307 of IPC along with other sections of IPC. Out of them, against 7 persons, charge sheet has been submitted under section 307 and other sections. Although
What is your case? No case is made out against you.
our case is that the injury report suggests that the injury is simple in nature. One injury is grievous against one person. And
No, 34 लगा होगा ना?
हाँ 34 तो लगा हुआ है.
34 लगा हुआ है तो फिर कैसे आपका ऐसे अलग अलग देखेंगे?
हमारे सेक्शन में 149 लगा हुआ है, 34 नहीं लगा.
ठीक है.
लेकिन हमारे केस में ये है कि ग्रीवियस अगर मान के लिए तो 325 का केस होगा. 325 में मजिस्ट्रेट ट्रायल है. और ये
डिस्चार्ज आपका है ना?
हाँ. अल्ट्रेशन ऑफ चार्ज भी हो सकता है. मतलब डिस्चार्ज में भी
आप बहस करिए. आपको क्या बहस करना है? हम लोग तो अपने मन से थोड़ी कुछ करेंगे.
नहीं ये हम नहीं कर रहे हैं. अभी तो कमिंग फॉर द फर्स्ट टाइम नोटिस इज रिक्वायर्ड टू बी इशूड.
ऐसे हम नोटिस नहीं करते. मैकेनिकली हम कोई केस में नोटिस
नहीं. ठीक. I'm passing first information report.
सेकंड आप में सुनेंगे.